Good afternoon. Welcome to the special call meeting of the State of Tennessee Peace Officer Standards and Training Commission. We have some members via Zoom and we have members present. Has everybody had a chance to look over the agenda? And okay. If everybody's had a chance to review the agenda, I'll accept a motion to approve.
Motion to approve.
Have a motion and a second. Any discussion of the agenda? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed? Hearing none, agenda is approved. Administrative matters.
A meeting of the Tennessee Peace Officer Standards and Training Commission is taking place remotely at 2 p.m. on February 22nd, 2022 via electronic or other means of communication. Notice of this meeting was posted on the Post Commission's and the Department of Commerce and Insurance's website. As there is not a physical quorum present, potentially a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to TCA 8-44-108B2, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. Furthermore, this determination by the commission is as follows. Due to the impossibility of having a quorum of members physically present and the immediate need of the Tennessee Peace Officer Standards and Training Commission, the Post Commission, to certify the eligibility of candidates to appear on the ballot for the office of sheriff pursuant to TCA 8-8-102 and 2-5-101A, the Post Commission believes a necessity exists that requires this meeting to be held by electronic or other means of communication. The matters to be considered by the Post Commission at this meeting require timely action by the Post Commission. Further, physical presence by a quorum of members of the Post Commission is not practical due to the severe and potentially dangerous weather events predicted to occur today. The Post Commission maintains that safe, open, and transparent public meetings can be conducted by electronic means. Post Commission members are currently unable to attend the meeting in person, and participation by a quorum of the members of the Post Commission by electronic or other means of communication is therefore necessary.
Thank you. Everybody understood the statement that was read in administrative matters? Okay, I'll entertain a motion to approve that statement.
Motion.
Have a motion and a second. Any discussion on the statement? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed? Motion carries. Thank you. Mr. Director, give us a roll call.
Commissioner Birchfield. Commissioner Cherry.
Here.
Commissioner Dunbar.
Here.
Commissioner Green. Here. Commissioner Faulkner.
Here.
Commissioner Forrester. Commissioner Halsey. Commissioner Jackson. Here. Commissioner Russell. Here. Commissioner Spangler.
Yes.
Commissioner Wagner. Commissioner Wright. Here. And Chairman Park.
Here. And also make note that Commissioner Forrester is here. His click of his mute was fast. Okay, we do have a quorum. Go ahead with the disclaimer, Mr. Secretary.
All Post Commission members have previously agreed to recuse themselves from any vote that would constitute a conflict of interest. The most obvious of these would include issues that involve our own departments or some we know personally. Because we've already agreed to this, it should be noted that on routine matters, it will be assumed non-verbally that these commissioners have abstained from that vote. In bigger, more controversial issues that may have a more overt conflict of interest, it may have an appearance of impropriety, those applicable commissioners will still verbally abstain from those votes.
Thank you. Minutes for the last meeting, the special call meeting, we don't have any minutes to approve, so we're going to move on to that. No decertification hearings to report. No pre-employment requirements. Moving on to page 3. No waivers to attend another academy. Nothing to report as far as basic training and specialized substitutions for certain in-service training. No waiver, no administrative waivers to look at. We have no 6-month waivers. Moving on to page 4. No departments for the 6-month rule. No 8-month rule waivers, no medical waivers, 0 military waivers. We have 0 applications for training officer. Moving on to page 5. We have 0 applications for certified instructor. We have 0 curriculum and test. We have no old business to report. Moving on to new business, Monroe County Sheriff's Office requests for the commission to determine if an applicant is qualified to run for sheriff of Monroe County, Tennessee. Who do we have appearing today as challenger?
I'm Robert Jolly here on behalf of Tommy Jones, the sheriff of Monroe County.
Could you come forward to the podium, please, sir?
Yes, sir.
Afternoon, Mr. Jolly. Thank you for being here.
Thank you, Your Honor.
Could you move forward with your testimony of challenge?
Yes. We are challenging Randy White's ability under the statute that was referred to as a candidate for the office of sheriff because he does not have at least 3 years of full-time experience as a post-certified law enforcement officer in the last 10 years. Mr. White was elected in 2014 to the position of sheriff. He was removed after an ouster suit in which the court, through Judge Ash and through the Court of Appeals opinion being found at 2015 Westlaw 5444126 from September the 16th of 2015, which was taken to the Supreme Court and denied on January 14th of 2016, that Mr. White was not a qualified candidate under this statute. Since that time, Mr. White was employed as the chief deputy originally, beginning on October the 17th of 2014. In Monroe County, we have paperwork that shows that. After he was employed as chief deputy, the Post Commission sent letters out both to the sheriff and to Director Libby Hicks of the Monroe County Department of Finance, in which this commission stated that Mr. White was inactive due to his fact that he did not enroll or complete the 3-week transition school that was held in March of 2015, that they gave 3 options to petition the Post Commission for another 6-month waiver to immediately enroll and approve a post-approved basic police school and to discontinue working Mr. White as a law enforcement officer. As a result of discussion, Mr. White was transferred to a non-law enforcement position that was jail administrator. That was done on May 1st of 2015. So it is the sheriff's position that up until that time, that Mr. White, as a result of court rulings and the statements by the Post Commission, was not a post-certified officer. He was transferred, he completed the transition school and went back to the chief deputy position in October of 2015. After he went back to the chief deputy position, he stayed in the Monroe County Sheriff's Office until he resigned from that position or was terminated on October the 27th of 2017. Since that time, Mr. White has had limited full-time law enforcement. He worked for the city of Tellico for a while, according to a letter obtained through the Open Records Act that Mr. White was a full-time officer from July the 6th of 2018 to when he resigned that position on September the 6th of 2018. So that is approximately a 2-month period, a little long period. So that's the only additional time that he would have other than the time that he served between October of 2015 and October of 2017 when he resigned that position. Under our calculation, that is less than the 3 years required full-time law enforcement experience. We have, while we do have a letter from Chief Parks, which was disclosed to us, we have affidavits from Patrick Hawkins, who is the mayor of Tellico during the applicable period, from Jason Crowder, who was a lieutenant and administrator in the Tellico Police Department during the applicable period, and from Doug Millsaps, who was also a member of the Tellico Police Department during the applicable period, all of which indicates that they were not aware that Mr. White was a full-time officer. We would also submit the charter of the town of Tellico Plains, section 5, part 7, which says that the mayor, who would be Patrick Hawkins, shall execute all hiring, firing, promotions, and demotions for employees. And so Mr. Hawkins, paragraph 5 of his affidavit, which states Randy White was not a full-time officer with the city of Tellico Plains Police Department. He worked part-time and only worked regular hours while his son was in the academy. After that, he worked part-time as needed. I did not tell Mr. White that he was a full-time officer. So we would submit that there is some serious question of whether or not Mr. White was actually a full-time officer for the city of Tellico. So if I have a group of documents, a copy of the Court of Appeals opinion from the Bill Bivens versus Randy White. We have documents from the Monroe County government showing when Mr. White was transferred from sheriff to chief deputy, from chief deputy to administrator. And then we have the termination notice, which shows that he was terminated on October the 27th of 2017. We also have copies of the post-mission letter that was previously sent, both of which are dated April the 29th of 2015. One directed to Sheriff Tommy Jones, and the other directed to Director Libby Hicks.
Thank you. Any questions from the board members of Mr. Jolly?
This is Forrester. If memory serves, you said you're talking about Tellico Plains. The mayor said he did not inform him that he was full-time. How many hours per week did he work when he was employed at Tellico Plains? Because the status of full-time per post rules is actually in the rules.
I have the documentation that I would be glad to provide to the commission, which shows that you could consider him to be full-time after that July the 6th date that's referred to in Mr. Park's letter. I'll be glad to provide those worksheets to the commission.
You said that he could be considered full-time after that date?
Under the statute, yes.
Okay. So did you include those dates in your calculations?
Yes. That's a 2-month period. So we show approximately 2 years, a month, and probably 2 more months. So a period of time of 27 months. That's with giving all the benefit to Mr. White as the potential that he would have.
Any further questions from the members to Mr. Jolly? Thank you, Mr. Jolly.
Would the commission like me to provide the questions, the paperwork provided from
Legal, would you like to have those copies?
We would love to get copies of that.
Thank you, Mr. Jolly. Is there anybody here representing the challenged?
Good afternoon. My name is Chuck Firks. I'm an attorney that practices in Knoxville, Tennessee, and surrounding areas. I'm here on behalf of Randy D. White, and we are ready to go forward to show that he does qualify, and we do dispute the records that were sent. And we have, I've got a folder for the commission that has everything I'm getting ready to tell you about. We also have witnesses here to testify about the work that he did and the hours that he did. It would be our position that he did work at least 3 years, it's over 3 years. Proof will show that he was elected sheriff in 2014. He took office on September the 1st, 2014, as sheriff. There was a lawsuit dispute over his hours back before 2014. In fact, I think we were in front of the commission on that issue. And the judge ruled that he didn't have the required hours before 2014 and before he took position as sheriff. And then he became the chief deputy in the next month and a half at the end of the time of the ruling of the court. So he stayed full-time as either the sheriff starting September 1, 2014, and continued that until he was terminated by Sheriff Jones right before the 2018 election. In fact, I would also point out that in 2018, Mr. White ran for sheriff and was certified by this body, claiming that he had his 3 years qualified to run as sheriff back in 2018. The disputed time that what they're talking about, I do have a book that I'm going to submit, and I have copies of this. And as Mr. Jolly said, there was a letter from the Post stating that Mr. White did not go to a training school, the three-week school, and that if he didn't take an option of asking for a waiver, then he couldn't continue to work as a law enforcement officer. Sheriff Jones actually filed the paperwork to get the option that came back before this body. And the body approved the waiver and allowed him to go to the next training session, which he did and he completed. We have those records. So during that whole time, he continued to work as chief deputy. What happened, there was a question of whether he was going to get paid or not. So the sheriff on his own took the jailer, chief jailer, Jeff Brown, and Randy White, the chief deputy, and just on paper said, well, I'm going to pay him as chief of the jail, and I'll pay Mr. Brown as the chief deputy. They never changed the positions. And we have witnesses here to testify that Randy White continued to work full-time with the Monroe County Sheriff's Department as the chief deputy. We have an affidavit from Libby Hicks. Libby Hicks was the finance director of Monroe County. She's the one that Mr. Jolly mentioned about getting the letter that started the process of getting this waiver. Shortly after the request was made, you'll see in Mrs. Hicks's affidavit that they continued, got the affidavit, and she says in her affidavit that he being Randy White, continued to work as chief deputy because she was having interactions with all of the departments, including Randy White. We also have testimony here today from Officer Denny Graham, who worked in narcotics during this questionable period of May the 1st, 2015 to July the 16th of 2015. When they say he became the chief jailer. Proof will show, and Mr. Graham is here with his records to show that he dealt with Randy White throughout that whole time, because the chief deputy was over narcotics. And so every time that they had to have any spending money, had to account for it, as you all are well aware, you have to go through the process. We have Mr. Graham's records showing during that period of time where he was getting Chief Deputy White to sign off on them because he was over the narcotics. We have those records, and he's here to testify to that. Also, we have an affidavit from Conway Mason, who also was working in narcotics, who says that he worked with Randy White throughout that questionable period that they're questioning, May 1st, 2015 to July the 16th of 2015. And then Miss Libby Hicks, in her affidavit that I have, says that they realized that they were still had that pay question, and so they flipped it back to where Mr. White was getting paid as the chief deputy. He never changed his duties. He never changed his experience. He worked full-time as the chief deputy throughout that whole time. That was his experience. Not the pay, it's his experience is what the statute relies upon. So that issue is a non-issue. I also have an affidavit from Jed Brown, who was the chief jailer. Jed says that he never stopped being the chief jailer during that time. That's what he did. He was the chief jailer. And so we have his affidavit that we'll submit to you as well. This is, I'm concerned that they've come to you and said, well, there wasn't that full-time experience. The truth of the matter is there was. Sheriff knows there was. All of the people that work with the sheriff department knows it was. I also have Debbie Burris, who is the city reporter for Tellico Plains, Tellico Plains. She's here today with her records. She will testify that Mr. White was paid as a full-time employee for 2 months at the Tellico Plains Police Department. And that I also have Jerry Miller here, who has the records of the daily activity records of Mr. White during those 2 months as full-time records. So he worked full-time with the Tellico Plains. And the only reason he left there was because he was asked by Mayor Ingram, who was the mayor of Monroe County, to come and take over the emergency ambulance service department. And that's why he left. That's what he's doing at this time. We say that if you look at the records from September 1, when he became sheriff, he worked full-time as sheriff. He was a law enforcement certified officer until October the 26th is when he switched to be the chief deputy. He worked full-time as a chief deputy. I'm sorry, I missed that. In October of 2014 is when he switched to be chief deputy. He never changed being full-time. And so he stayed there until October the 26th, 2017, when Sheriff Jones, who they were both running for the same position, terminated. So then he went and worked for the Tellico for those 2 months. Our records show that the time that he worked with Monroe County alone was 3 years, 1 month, and 26 days. So if you say, well, during the time that he was getting this pay question on July the 16th, May the 1st to July the 15th is 2 months and 16 days. So if you even accept the fact that since he was working as the chief deputy all that time, but only getting paid as the jailer, that would only be 2 months and 16 days. Well, he had a total of 3 years and 1 month and 26 days overall with Monroe County. If you back that out and then add the 2 months that you worked over in Tellico Plains, you still are over 3 months. So he has the requisite 3 months really over 3 months, that is required by the statute. And the statute doesn't say you're paid full-time. It's full-time experience. So the question is, what was his experience throughout all of Monroe County? And I don't think that you'll find anybody coming here and say that he wasn't active and performing the duties of the chief deputy throughout the entire time with Monroe County. We have witnesses who are going to tell you that. So our position is he does have the requisite 3 years certified officer experience that he did. He never lost his certification. The only question was that he thought he didn't get that repeat training. He had missed a training or something. I don't remember what it was. The lawsuit was over what the hours were or the time was before. And I think I recognize some of you that might have been part of that at that time. So it was a question of that. But there is no question at this time. And there's no question that he was the chief deputy throughout all of Monroe County. And that was what he was doing every day that he was working there. That was his experience. And that's what you're actually doing, not how one is labeled on payment. And so we have these records. In fact, I can give these records. I've got a book here. I've got his certification when he went to the training school, the three-week training school. I've got the certification of when this board certified him in 2017 with the 3 years that he had with Monroe County. The same thing that they're now complaining about. They knew then that he had worked for 3 years. They didn't raise that back in 2017 and 18 when he ran for sheriff and was qualified here, because they knew he was the chief deputy. It's only now that they want to come in and try to not let him run as sheriff to get him out of the way for this next coming election. We think he's entitled to it. We think that he improved it. And I have this and I have some other copies. I don't know who give it, and I just hand this to you. Thanks. So if you want me to, we can go ahead and present this proof that we have. You want me to go forward now at this time?
Oh, yeah, sir, I appreciate it. Just hold that for just a moment.
Sure.
Are you done with your response to the challenge?
Yes.
Members of the board, you've heard the response to the challenge. Is there any questions of this gentleman as to his testimony?
Mr. Burke, what did he do between 2012 and 2014? Was he employed?
2012,
Yes, sir.
before the sheriff's election.
Before he went to the sheriff's office in September of 2014. Yes, sir.
He worked at Von Orr, worked there. He worked at the emergency room. He worked nights at Von Orr.
Was he a full-time police officer?
He was.
Do you have records for that?
I didn't bring any of that. That was what the
It's
court.
within the 10-year period.
It was.
It's within the 10-year period.
Yeah. Well, the court, you're correct, and there were some hours that the court approved. I did not bring that. I mean, that the court did approve. We did not bring that, but he did within those 10 years. Yes, he did have some hours. I think Mr. Jolly may say he has the record. I think the court's opinion would say that he had certain hours in that time as well. There was a question of when he was at Von Orr. Part of that was a questionable period of time that the judge ruled that didn't qualify him for 3 years back. But he did have, yes, sir, you're correct. He did have some full-time work during that period of time, back 2012, 13 period of time. That is correct. Was
he full-time at Von Orr Police Department?
He was at nighttime, and what the court found is that he did. What the testimony was from the chief of police is that he said, Mr. White, since you're going to be running for sheriff, I don't want you out here arresting a bunch of people. So he didn't have any call-ins or in any period of time when he had to go and arrest people or make calls and so forth. He set up at the bridge and he also patrolled the area.
Well, what we need to know, sir, is the board, in these qualifications, it's 10 years back, doesn't matter. And if he, and that, you know, it's 2022, so back 10 years. Was he a full-time employee of Von Orr Police Department? Because that would also include in his
He
time.
was, to answer your question, he was.
Okay, how long was he an employee of Von Orr Police Department
I
full-time?
didn't bring those records.
Is he here to explain that to
Yes,
us?
he is. This is Brandon. Yes, sir. I was there just over a year, and I think at that time, the question came in the fact that only can testify to this. What they discontinued my time on was primary source of income. But during that time, I worked on, I was working at EMS at the same time. I made more money at the ambulance service than I did working at the police. That's where they.
How did they have you labeled at the city of Von Orr and how, full-time?
Yes, sir.
And how was you labeled in the CADIS at that time, in the post-commission system?
Full-time, sir.
How many hours were you working?
I'm working about 52 hours a week.
Okay,
Excuse me.
and how many, do you have that down as an exact time? From the time you started to the time you end?
Yeah, I don't have to.
Can you get that?
Yes.
Okay, and move forward from that time, where was the next gap at? You moved, and in law enforcement, I'm not worried about your EMS or if you was doing underwater basket weaving. I'm looking at law enforcement.
Yeah, and I was hired, but I got elected for sheriff in 2014.
How long was you there?
I was sheriff from September 1st until October 16th is the day I left that office. A year of 2014. Then I went in as chief deputy that day, 16th of 2014. And I was there until I was terminated on October the 26th of 2017. And then the next was July, actually part-time July or January of 2018 until July 6th of 2018. I went full-time for 2 months. I was there until September 6th.
Okay, if you took the combination of time that your attorney gave us and was saying it was 3 months and or 3 years and how many months?
The sheriff's department would be 3 years, 1 month.
I'm talking total.
Oh, it would be 3 years, 3 months, 26 days.
Was the Von Orr,
Bonus time was.
what would it be if you had that? Because it goes back 10 years.
If we added that to it, it would be actually 4 years, 3 months.
Because it's three full, it's very clear in the law, 3 full-time years of service, doesn't matter if it's broken up within the last 10 years,
And from the date of the affidavit, we
from the
received.
date of affidavit.
So we go back to December the 21st, 2011. That's the 10-year period, 2021 to 2020.
And I'm going to revert, thank you,
Yes,
sir. So I'm going, at this time, I'm going to turn to legal. And legal, can you
I give you
tell
advice.
us exactly what you've come up with and along with Director Mines?
Yes, sir. The statute provides, and this is Tennessee Code annotated 8-8-102. E is if a candidate's qualifications are challenged pursuant to subsection D, post commission shall 1, notify the candidate of the challenge, 2, review and verify the candidate's required qualifications identified in subsection A. Number 3, review and verify the candidate's affidavit and psychological evaluation form in accordance with subsection B. And 4, if the post commission determines the candidate does not possess the required qualification, sheriff shall A, disqualify the candidate and notify the county commission of determination no later than 12 o'clock noon prevailing time of the 7th day of the qualifying deadline as determined by 25101 A. What we've done with it, we received his application, and I will turn to Deputy Director Mines. We would go back 10 years from the date of the affidavit to determine whether 3 years of full-time experience in that last 10. And Deputy Director Mines will explain, we calculated by looking at the records provided, as well as this is why we require paperwork in the gated system to be updated and maintained so strictly by all the police departments, so that we can use that as the verification of what we have a record of.
And that would include such as change of status.
Yes, that is required by the rules and the requirement to be entered on change of statuses and requirements. Deputy Director Mines.
So what I did was, when I want to go into the system, of course, as Mr. Underwood stated, I have to go back 10 years from the date of the affidavit. This affidavit is dated December the 21st of 2021. I go back to 10 years from that date, which takes me back to December the 21st, 2011. Anytime in between there is time that I count that I got in Acatus. According to his Acatus file that I have, I went from 2014, September 1st, 2014, and forward up to when he was released from his position there at Monroe County, which was October 27, 2017. After calculating that, that came out to 3 years, 1 month, and 26 days from what I had. Did not have any for Nor time simply because it wasn't in Acatus. But if that would have been in there and it would have went not below December the 21st, 2011, I would have counted that time.
So for his agency that's entered the information into a case, he was working full-time for that period.
Yes, sir.
That was the sheriff responsibility and their training officer entering the information on behalf of this officer.
Yes, sir.
Board members, is there any questions of legal or Director Mines?
Just a
General Terry, go ahead.
clarification. So where he was, this flip-flop and paid it as holding one office, but actually functioning in another office, that didn't come up in the case. That doesn't, this is something that was,
If that happened, they did not notify the post commission that they did that.
so the agency has indicated that he was a full-time officer in law enforcement.
Yes.
Okay, and that's as far as you need to go.
That's what we maintain the records and require that for use of it.
And he would have received in-service pay.
If you'd have been, yes, ma'am.
And we can review, see if did he receive an annual in-service pay for this
I
year?
did not go and review.
Any further questions?
We respond briefly to statements that were made.
Yes, sir. Stand by just a moment, Mr. Jordan. Any further discussion of the members so far or what legal and Director Mines has commented about the status, changes of status, current status, previous status, or from thereof?
If I'm correct, the rules require change of status within 10 days of any change of status of an officer to be provided to the post commission by the employing agency.
I'm sorry, did you ask me a question?
No, sir. Hearing no further questions of Chief Legal or Director Mines, I will revert back to Mr. Jolly.
Members of the commission, in response to the questions concerning the employment at Vonore, if you look at the opinion of the Court of Appeals in this matter, when they considered the election issue, on page 8 of that opinion, I believe it was copied for the board, the court found that Mr. White's employment with BPD cannot be classified as full-time experience pursuant to 38-8-1012 because his primary source of income was derived from his employment as the director of EFS. So there is a conclusive finding by the Court of Appeals involving Mr. White that the bond award time is not full-time as he has asserted before the court. In that opinion. Further, we would submit to the commission that the letter that was sent, 2 copies of which were included, one to Ms. Hicks and one to the sheriff's office, essentially threaten those individuals if Mr. White is kept on because he is not qualified to hold that position. And I seriously doubt that this commission would authorize any member of its employee to send that type of letter where threatening elected agencies and members of a government with prosecution under a Class A misdemeanor if he was in fact qualified at that time. So we would suggest to the commission that what is being argued for is what the courts have previously said he was not qualified to receive because he was only a part-time employee, not a full-time employee. So when he held the position of sheriff, which he was removed from because he was not qualified legally for that job, and when he held the position of chief deputy, which this commission in its letter indicated he was not qualified for under the circumstances, that none of that time should be counted as experience for running for office again. As to the waiver issue that is being argued, that since he was allowed to be on the ballot in 2018, sometimes process goes, and understanding that this commission does not do its own investigation, but instead relies on objections to come forward. An objection was made this time to show that Mr. White was not qualified and is not qualified to run for the office of sheriff. To say otherwise would be to belittle the findings of the Court of Appeals in Mr. White's case, which held that he was not qualified after Judge Ash found that he was not qualified, and to belittle the prior work of the investigators at this office who sent out the threatening letter saying, you better do something right or we're going to come and get you. And you will notice that it was shortly after that time that there was a change of status within the Monroe County government, changing Mr. White's status from chief deputy, for which he was not qualified according to the letter of the Post Commission employee, and to jail administrator. So we would submit that Mr. White cannot rely on any of those time periods, any of the time periods which prior courts and judicial bodies have said he was not qualified, to say that he is qualified to run for sheriff in this election.
The letter references from former commission member Ray Ferris explaining that he would need to attend transition school, re-attend basic, or the agency must obtain a waiver. They removed him. They did send him to transition school eventually. He did complete transition school. So that is only available to law enforcement officers, not to jailers.
And I will go on and add in this that was sent by the sheriff at that time, he listed Von Air Police Department, March 2012 to March of 2013. For the title of chief deputy, Monroe County Sheriff's Office, 94 to 407, 0897 or 0897 to 1 of 04. Got the dates a little off there. And also Madisonville Police Department, and that goes back 92, 94. He completed the transition school. But what we have a problem with is notification of this body for a change of status, that is the records that we keep up with, and what Director Mines has gotten and has said that the man qualifies is based off the information provided by Monroe County for ACADIS, which is the record body that we go by.
So even though the Monroe County was communicating with members of the commission, the lack of a formal letter is what is going to prove that there was communication.
Well, there's rules set forth to this body that has gone to every administrator of law enforcement in this state that says, when you have a change of status, you have X amount of time to notify this body so that we can avoid matters like this. But in this case, Mr. Jolly, at this current time, with all due respect, it's backfired on the seated sheriff. Whereas if he had done his due diligence to this body, the testimony you're giving may have counted if that is indeed what happened. But he sent him to transition school, but there's no change in this status. And this is what we have to go by, because the sheriff says in here to Post Commission, this man is full-time chief deputy.
What was the date of that, sir?
That he was promoted was October 16, 2014. Today he was promoted to chief deputy.
which was without.
May the 4th, 2015, he signs him to send him into transition school. And marking as chief deputy.
And this is on the back of the form.
Well, the older matter, he was chief deputy until the post commission notified in May of 2015, April 29th was a specific day that he was not qualified for that position.
Yes.
Heard what Mr. Jolly is saying, the letter that I received from Mr. stating that, I see that wrong. I'll make this very quick. Ma'am, to answer your question, Mr. White did not receive any pay supplements. That was one of the questions that he put out. I think we submitted 2015 and 16 votes that he was denied because of the transition school.
And could you introduce yourself for the record, please?
I'm Sheriff Tom Jones from Monroe County. The wording on this, let me look at it real quick and find it here. Randy White's current status will remain inactive due to the fact he did not enroll in the transition school. And it goes on to the three options that we had. And then to continue to work Mr. White in an inactive status is a violation of the post rules, TCA code 38A-105. What we're asking, what I'm asking is, when I received this letter on May the 1st, 2015, from the date that we took office, Mr. White took office September 1, 2014. 6 weeks or so later, he was the chief deputy. I was the sheriff. He worked and functioned in that position. There's no doubt about that. But with this stating that he was inactive until he continued, he completed the transition. Well, it does this time count when he was inactive. We were committed to class A misdemeanor. And he never received any pay supplement. Now, if this time counts from, say, May 1 back to September 1, and he's not received pay supplement for 3 years, I know we submitted, he was denied. Well, the state of Tennessee probably owes him 3 in-service checks.
Could be possible, but attending the transition school would reactivate his status,
Yes, sir.
backdating it to the date it was okay.
So it will back that.
It would count it.
Okay.
But you have so many times to appeal for that. If you file for it and then denied it, I don't know.
What was that, sir?
I don't know. The denial of the pay supplement would be a totally separate issue. We'd be glad to look into that, but
Yeah, it was also denied after he attended the transition school the next year. Because I think it is, you have to be out of the academy or transition to active for 8 months, I think, prior to.
yes.
Y'all denied it.
And that is very possible, but it's not, because of the denial of the supplement is a subcategory of the rule. If I'm just trying to put this in layman's terms here, it would not determine his post certification. Just because you didn't get a stipend of money does not mean he was not post certified. If that,
I mean, I can't say he completed the training those years. I don't know.
Well,
Does that make sense? Those are other issues that go on determining pay supplement.
Question was on this and letter from you guys from the post commission stating that he was inactive.
and you responded to that, Sheriff, by sending him, you did the right thing.
I think it
You
was-
took option number 3.
You took
too.
option number 3, that is right.
I think it was 2015.
No,
I think option 1. You took
Option 1.
You took option 1.
Yes, it was option.
Option 1. And then that activated him, which brought him back into compliance, and it still shows in a CADIS. And that's, you know, with the way they keep up with the records here, and it affects all of us in law enforcement. They have to go by what is right here. And that is only supplied by those that supply it, which would, in this case, be you.
The first time I spoke with Mr. Mines, he was showing it was, his activation date was October 2015, and he said it was 2017. This is the conversation we had. So that was also,
We've never had that conversation.
There is 8 months there between 14 and 15, I was counting, but
Yeah.
if you worked for September the 1st, 2014 to October the 27th of 2017, that's easily 3 years.
That's our question.
Thank you.
Mr. Chairman,
Yes, sir. You recognize Commissioner Wright.
based upon what we have in the cadence for the 3 months, 3 years, 1 month, 26 days. I'll make a motion that we deny the challenge and allow Mr. White to be on the Monroe County Sheriff.
We have a motion on the table. Do I hear a second? Second. Have a second on the table. Any discussion on this particular motion? If I hear no discussion on this motion, all in favor of the motion indicate by saying aye. Aye. Opposed to this motion, all indicate by saying no. Motion carries. Now, due to this motion, legal, if you would explain to the challengers what they can do moving
They have,
forward.
they have a right to the Chancery Court is the next level of appeal to this, if that's so chosen. We will be notifying the election board of Monroe County by noon on Thursday. Mr. White's eligibility to appear on the ballot.
Any questions? Hearing no questions, if there's no further new business to discuss, I'll entertain a motion to adjourn.
Motion to adjourn.
All in favor, yes, sir.
I just want to make sure that I have submitted this. Could that be part of the record? Documents?
Absolutely. Yes, sir. It is so entered. Motion carries. Adjourn. I've been in federal court all week. Maybe she's been banged away.
Yeah.
Yeah.